Oh, hey friends. Josh Yeager, Fiduciary Governance High Plains Drifter, on a walk with my buddy Dodger. Dodger's on the leash right now because he was bad. He tried to run away. And I wanted to share with you a little anecdote, a quip, an example of a conversation I was having with a client a couple of days ago about the design of their estate plan. So we were talking about the dispositive terms. That means what happens after mom and dad die, how much do the kids get, how much does charity get, how much does the IRS get. So we were having this conversation with this fella. And he had created this very convoluted plan of, well, if my estate is this size, then I want the kids to get this much. And if the estate is larger than that, then I want the kids to get a different amount and charities to get another amount. And if the estate is below this amount and added cost of living elements to each of these if-thens, and I shared with him that he and I had a different point of view about estate plans. He was hoping and thinking that by putting a lot of effort and time into the dispositive terms right now, he could set it and forget it for the next 20 years because he would have anticipated everything. The needs of the kids, the increase of his wealth, or the potential decrease of his wealth, the future purchasing power of the inheritance by the kids, the future grandkids that may be born that aren't yet born. And I shared with him, you know what? That's just different than I see estate planning. I think estate planning is more about assuming that you get hit by a bus tomorrow. And what do you hope for your assets at that point? And what is the appropriate allocation of your assets with an assumption that you're not here to oversee those assets? And then, if life changes, which for sure it will, you can always change that component of the plan. You don't have to rewrite the entire trust document. You can just do an amendment to the paragraph that says, this is who gets how much and under what circumstances. So if the estate goes up by a bunch, fine, make a change. Or if it goes down by a bunch, no sweat, a couple of paragraphs. So that's the difference between an amendment to a trust, which is just taking a few sections of the trust and changing it. A couple of pages, sign the bottom, no sweat. We've got the original trust and then we got an amendment to the trust. That's the difference between an amendment and something called an amendment and a restatement, which is basically everything that has happened up to this point gets torn up and doesn't exist anymore. And this is a new version of everything. So when you're looking at doing the estate planning, know that you don't have to go through the whole exhaustive process of redrafting all of the 35 pages of the trust with all the therefores and if-thens and shalls and shall-nots and 25% at age 25 and 30% at age 30, etc. You could just say, look, going to get my estate plan. That's the foundation planning. And then every couple of years, I'm going to do a tweak to the estate plan. If the current instructions aren't right, if something's changed, or if my assets have changed, or the relationship with the kids have changed. So that's something important to think about. I'm not saying I'm right. I'm just saying it's one point of view. And I've found that it makes the planning process more simple because we don't have to try to be clairvoyant of all the potential permutations of how the future may roll out. That would be difficult. It's kind of like the Marvel, what do they call it? The multiverse. Trying to do estate planning in the multiverse is difficult. Let's just try to do it for here and now for the next couple of years. And make a tweak if we find out we're wrong. Okay, friends. That ends the talk. Ciao.